If you are an unmarried person, but you are in a relationship, in a partnership with someone, you probably made the decision, we don't want to get married, but we want to live as partners. In Washington State, we call that a committed intimate relationship, especially if you commingle your finances and you hold yourself out as spouses. What we often see as estate planning and elder law attorneys, though, is that the couple didn't think through estate planning considerations. That's not surprising. Estate planning is a very proactive thing to do. Oftentimes people put it off. They don't want to, expend money on it, the cost of it. They don't understand why they need it. I want to share with you why you might need an estate plan if you are in a committed intimate relationship. Perhaps you and your partner own a house together. Both of your names are on the house. Likely, though, you don't hold title to that house as joint tenants with right of survivorship. The default is that you hold it as what's called tenants in common. Now, why do you care about that? Why you care about that is if you don't have a will that says, when I die, I want my house to go to my partner, your partner is not going to get your half of the house. Let me give you an example. Let's say that the partner dies, that one of these two partners dies. There's no will. They own a house together. The partner who died, of course, is unmarried. They have no children. Their parents are deceased. All they have is a brother, for example. So when that partner dies, the half of the house that's owned by that partner goes to the brother. And the brother may or may not be willing to give up his interest in that house to the other partner so that she can still live in that house. So she will have to sell the house and take only her one half of the house. The brother of the deceased partner gets the other one half. Now, if this couple in this committed intimate relationship had thought about it, they would have made sure that the titling to the property was done correctly, joint tenants with right of survivorship. But of course they didn't know to think about that. And they just didn't think, let's say they're in their 30s or 40s, they just didn't think that one of them would die that young. So they didn't think about the fact that they needed a will. As a result, not only is the surviving partner dealing with the tragedy of the loss of her partner, her loved one, but she's losing her house as well. And it could be to a brother that wasn't even liked by the deceased partner. Who knows? What I'm trying to express to you is having a will is critically important if you are an unmarried person. What if the partner who is in an accident didn't die, but they're in the hospital? Well, who is going to speak on behalf of that injured partner? It will not be the well partner in this committed intimate relationship. They have no legal rights. What that means is, under the scenario I just described, it's the brother of this injured partner who is going to be giving directions as to what the doctor should do for medical treatment. And the real partner, the well partner, who you would expect would be listened to and be speaking on behalf of her loved one, she can't even go to the hospital. She can't even get any information. She is excluded because she has no legal rights. How do you fix that? Durable powers of attorney, a durable power of attorney for health care, giving that each partner rights to speak on behalf of each other, having the health care directive that says what your wishes would be, having a durable power of attorney for finances so that the one partner can deal with all the financial matters. So more so than any other situation I can think of, having an estate plan with a will and durable powers of attorney is critically important to unmarried people.